So this is Don Lane. I was happy to speak at the first HAPIA conference today. I talked about Ohio developments in the areas of appraisal and suit limitation provisions. The insurance company, in this case, the German-American Insurance Company, actually tried to enforce the appraisal clause against the insurers because the insurers brought suit without going through appraisal. Now, as we all know who practice in this field, that's a little bit different than what we see these days. But anyway, as far back as 1907, the Ohio Supreme Court said, we believe that an appraisal clause should be enforced. The parties who agreed in an insurance policy to go to appraisal should actually do that. So this issue's been around for a while. So I put the standard appraisal clause up here, part of it, and the highlighted language there is really what we see in most insurance disputes. If you or we fail to agree on the amount of the loss, either party can demand that the amount of the loss be set by appraisal. So the jumping off point for a lot of these disputes is that language, amount of loss. How have the courts interpreted that? So first of all, the insurance company argument goes something like this. And you're most often going to see this, and I know a lot of you are roofers, you're going to most often see this in roof repair cases, where you go to a loss, there has been damage as a result of a covered peril, most often storm, hail, windstorm. The insurer argument focuses on the fact that the court must decide the extent of coverage, i.e. does the roof need to be replaced, and that the appraisal clause only applies to how much is that going to cost. So that's the argument, and that's why you have a lot of insurers denying appraisal in these cases. They're saying this dispute is not about the amount of the loss, but it's about the extent of the loss, and therefore it doesn't belong in appraisal because of that amount of loss language. So the question is, should we have a memorandum of appraisal up front so everybody is clear what the subject matter of the appraisal is? And in this case, the insurance company's adjuster is actually intervening in the process. I think that's bad faith. Do we have a memorandum? Yes, that's a good idea. When you make your appraisal demand, it's good to set up in the appraisal demand the scope of what you're demanding be appraised if you're the demanding appraisal on behalf of the insured. And then once the appraisers are appointed, it wouldn't hurt to say this is what we are agreeing is going to be appraised. In writing, the two appraisers come up with that memorandum and sign it. Now obviously, you're not going to have an umpire signing that because of the policy language. The two appraisers are supposed to try to resolve the claim themselves, so they would be the ones that would be party to that memorandum. And that way, you're going to define the scope of the appraisal, and you're not going to give the insurance company the chance then to try to intervene and carve out their own scope.